Okay, thank you, ladies and gentlemen. Welcome to the Honorable Mr. Pavlo Liutikov for the topic, the concept and the Eastern interpretation of law, the from University of Custom Finance. Today's session is being live streamed on Universitas STEKOM YouTube channel. And now, please let me read our agenda this afternoon. First, we will start with class presentation by Mr. Pavlo and continue with the Q&A session and time for picture and the closing. So let's begin with the class today. Mr. Pavlo, the time is yours. Thank you.
Thank you. Thank you, my dear colleagues. Allow me to introduce myself. My name is Pavlo Lutikov. I am a doctor of law professor. I have been doing research in the field of administrative law for a long time. I would like to dedicate today's meeting and our conversation to a very important topic that is relevant for any state and its legal systems: the concept and the essence interpretation of law. But before starting the lecture, I would like to warn you that in the event of an air alert, I will be forced to take cover and rehearse the lecture for my own safety, because in recent days Russians have not spared their missiles for peaceful Ukrainian cities and towns. However, I hope that everything will be calm today. So let's get started. The complexity of the legal interpretation process and the ambiguity of its results always arouse genuine curiosity on the part of both legal scholars who study general theoretical issues and scholars who investigate the problems of branch legal sciences. By and large, starting from the 40 and 60 of the last century, that is, from the moment of the final formation of the so-called theory of legal interpretation in the domestic legal doctrine, and until now, representatives of the legal scientific community in search of the most accurate and complete answer to the question: what represents the interpretation of law? What is its real resource and potential? What are the object and what are the subject of this difficult intellectual violational process? Taking into account the fact that social relations are essentially dynamic and rapidly changing, and as a result, the law that regulates them is prone to transformation, it can be quite objectively assumed that the above-mentioned scientific questions or the interpretation of legal norms will never lose their relevance and public importance. All the more it is worth taking into account the fact that law, changing its regulatory capabilities, requires revision and updating of approaches to its interpretation. It seems that including these factors influence the fact that even by a modest estimate, domestic and foreign scientists have prepared more than 100 dissertation and monographic studies devoted to various issues of legal interpretation. As the number of scientific articles in general cannot be counted. It is natural that such a variety of scientific material indicates ambiguity in the solution of such difficult questions for science. And in fact, the complexity determined the fact that we can safely talk about several independent and diametrically opposed views on the interpretation of law and its norms. Currently, there are several approaches and trends to determine the essence of legal interpretation. In particular, some scientists consider interpretation as a special mental process aimed at elucidating legal norms. Others, at the process of clarifying legal prescription. Others understand interpretation as a single process of explanation legal norms. Others as a type of legal activities to establish the meaning of law and legal prescriptions, the content of normative legal acts for the purpose of their application, and some scientists as a special type of legal practice. A denied analysis of the above-mentioned approaches made it possible to critically approach certain theoretical concepts expressed in the columns of legal literature, both in the past and the current period of the development of legal doctrine. Therefore, using the example of understanding the most well-known traditional and not standard ideas, we will try to get closer to the answer to the question of what, in our understanding, is the interpretation of law, its essence and purpose. In the Soviet period of the development of the legal science in matters of legal interpretation, for the sake of justice, it should be noted among the main ones that the Soviet legal doctrine, rejecting the ideas of the representatives and pre-revolutionary legal science, was able to present its views on the problems of interpreting law and its norms as fairly weighty arguments. On the other hand, aggressive rhetoric regarding the approaches of foreign scientists and those domestic researchers who espoused a concept of legal interpretation similar to that of Western scientists was not quite correct and objective. However, the real basis of the modern view of the theory of interpretation by Western researchers, including the works of American lawyers Thayer and Holmes, in which they describe the legal interpretation work of a judge, which is aimed at finding out the real meaning of the text. Holmes, for example, made a distinction between meaning content in theory and meaning content in practice. I quote, "It is true that in theory a document has one certain meaning and no other. And it's not true that in practice the meaning of words and phrases has only one meaning and no other. According to the lawyer, interpretation is the process based on the interpreter's understanding of the general rules of language, which does not require and special knowledge apart from mastering the general rules of word usage. Among modern foreign specialists in the field of legal interpretation, there are discussions about the ratio of static and dynamic interpretation, their regularities, etc. In particular, there is no unity in the issue of the law-making character of interpretation. Does it exist at all? The limits of the kind of lawmaking activity, the relationship of dynamic interpretation with democratic governance and the doctrine of separation of powers, etc. The most significant works among the proposing series of interpretation are Dworkin's The Empire of Law, Marmor's Interpretation and Legal Theory, The Philosophy of Law, and Barak's Proposed Interpretation in Law. Among other foreign researchers, one can mention such outstanding scientists as Cardoso, Bolnov, Beatty, Bergel, Llewellyn, Ricke, Ridney, Esse, Hart, Ross, McCormick, and others, whose works were devoted to the problems of legal interpretation. So, for example, Richard Dworkin, who we believe in the context of our interpretation of law actually talks about hermeneutics, notes that to interpret means to try to understand something, a statement, a gesture, a text, a poem, or picture, for example, in a specific and special way. This means trying to reveal the motives or intentions of the author in the way he spoke or acted or wrote or painted. So interpreting a social practice as your practice of politeness can only mean discovering the intentions of its members, one by one. Second interpretation aims to show the object of interpretation, the behavior or poem or painting or text in question, exactly is exactly as it really is, not as you suggest, through rose-colored glasses or in the best light. This means to find the true historical intentions or its authors, and not to impose the values of the interpreter on the works of the authors. Instead, Murmur focuses on interpretation as a means of realizing certain objective values, values that interpretation necessarily embodies if the power institution play the social game called democracy and rule of law. Murmur's concept in legal literature was called conceptual prescriptivism. The law should be such that it corresponds to the concept we have about it. The concept, in turn, depends on objective, albeit conventional, values. The law undertakes to implement them. According to Murmur, interpretation can be understood in a broad and narrow sense. In turn, Barak, in his study Targeted Interpretation in Law, recognizing that interpretation in law has different definitions and there are different approaches to its understanding, formulated the concept of legal interpretation, which means mental activity that gives meaning to the legal text. The requirement of rationality, reasonableness, and emphasized by Barak is key. Casting lots is not inherent in imperative activity. Interpretation is an intellectual activity related to determine the content of normative prescription, which is deduced from the text. The text that is the object of interpretation can be general, constitution, law, precedent, custom, and can be individual, contract, will, etc. It can be written or oral. Moreover, for purposes of interpretation, any conduct that creates a legal rule is a text. Interpretation in law, as Barak points out, is is the mental process by which we understand the text. Through interpretation, we learn about the normative message of the text, derive the legal meaning, content of the text from the semantic meaning, and interpreter translates human language into legal language. It gives to static law a dynamism. He introduces the legal norm into practice. To interpret a text, according to Barak, means to choose its legal meaning among a certain number of semantic possibilities, to decide which of the semantic meanings of the text constitutes its proper legal meaning. In the context of the analysis of scientific research, in the area of the problem, it was paying special attention to the through study of Scalia and Garner, reading the law, interpretation of legal text, in which its authors reveal in detail the principles and canons of interpretation. This research is particularly interesting due to the fact that Scalia and Gardner were judges of the US Supreme Court at the time of preparation and publication of the monography. In total, 70 canons of interpretation are revealed in the book, with corresponding examples from practice as illustrations of their action, which will be discussed in more detail in following parts in the study. The works of European legal philosophers has studied in detail not only the legal aspects of interpretation, but also its philological component uh, are of great importance for the modern theory interpretation. For example, Italian lawmaker Betti, adhering to the Hermeneutic tradition, created a general set of practical procedures and rules for interpreting text in the work, generally theory of interpretation. As can be seen from his concept, the subject of hermeneutic understanding is the forms, structures, in which the spirit of the author is objectified. Under such conditions, understanding the text is a sequential process of recognition, reproduction, and normalization. At the first stage, the object is comprehended based on its autonomy and immanent logic of existence. On the second, the subject of interpretation is reproduced through the principle of the integrity of its internet connections. At the final stage, the conclusions obtained from the previous stage are implemented. At the same time, the interest relevance of the subject is manifested, which is caused by the inclusion of the subject in the intellectual horizon of the interpreter. Also, Rickert studied conflict of interpretation cannot be overlooked, in which he notes that the task of the universal theory of implementation is to reveal meaningful structures that have something more than just a certain essence.
I'm
Hermeneutic,
sorry, sir. Oh, yeah, do
yes,
you have PPT for the share screen?
I'm sorry?
Do you have PPT PowerPoint file for the share screen?
No, no, sorry.
Oh, okay, it's okay. Thank just for confirmation. Thank you so much. Yeah, go
Okay.
ahead, please. Thanks.
I can share my lecture if it's necessary. Okay,
Okay,
just a moment, just a moment. Is it good condition, for example?
yeah, it's
Yes?
okay.
Okay, okay. Also, Rick's study conflict of interpretation cannot be overlooked, in which he notes that the task of the universal theory of interpretation is to reveal meaningful structures that have something more than just a certain essence. Hermeneutic interpretation, according to Enrique, is aimed at understanding the symbol for the understanding of which it is necessary to establish a feedback relationship between the latter and its meditated lived experience. According to the French thinker, the corresponding procedure is a key point of all hermeneutics. As a result, Rieke redirects the subject to the interpretation of non-verbal phenomena. In this case, the methodology should include, in addition to theories of interpretation, also uh, and physical analysis and structuralism, which reduce the establishment of content to a subject-independent construction of language, symbols, and with and curious characteristics. Any understanding, according to Enrique, is meditated by signs and symbols, and therefore the universal method of interpretation needs to be supplemented by structural and semiotic analysis. Just a moment. As a preliminary summary, we can say that, of course, not all the ideas of foreign scientists regarding interpretation are applicable in our conditions of lawmaking and law enforcement. But the outline of some rules, including the so-called canons of interpretation, should be considered and unconditional, if it not the main advantage. Western theory of interpretation. Returning to the analysis of Ukrainian and post-Soviet legal literature, we note that the vast majority of modern domestic researchers of legal interpretation problems, both at the level of general legal theory and the level of branch studies, are not inclined to share the above described thesis of foreign legal scholars, generally continuing and enriching the theoretical property of Soviet legal theorists. However, some domestic scientists use and rely on the works of foreign researchers, adopting them to the Ukrainian, for example, realities of lawmaking and law enforcement. I will give some of them below for your reference. Those prima sustained the close connection of the interpretation of legal norms with some philosophical teachings, in particular with hermeneutics and phenomenology. Scientists draw attention to the fact that when studying the phenomena of interpretation, the existence of static and dynamic, as well as subjective and objective methods should be taken into account. At the same time, he made a conclusion about the expediency of using all the mentioned methods, highlighting one of them depending on the specific problem. Among the aforementioned, the scientist outlines the main features of the interpretation of law. For example, it is a type of legal activity, has a cognitive, intellectual, mental, creativity character, has a target nature, has a clarifying specification nature which is determined by the normative nature of the law, has an indirect nature, is carried out by various entities, the particulars of which determine the type of interpretation is based on certain principles. On the basis of these identified features, Prima formulates the definition of the interpretation of law as a type of legal activity that has a cognitive character, is based on certain principles, and is carried out by the relevant subject in order to find and clarify the content of legal norms, and necessary cases also provides for its differentiation, verification, or explanation for other subjects. Semenov claims that the interpretation of legal norms is a process of clarifying the exact meaning, the content of legal norm being interpreted, and activity aimed at revealing the dynamic objective meaning contained in the legal norm conditioned by the modern needs of social development. The signs of any legal interpretation are the purpose of interpretation is to clarify the true content of legal norms, to reveal their inner meaning. The content of legal interpretation as a set of special techniques and methods aimed at achieving the specified goal. Interpretation is an integral part of the process of implementing legal norms. The need for interpretation arises from the legal nature of the process of implementing legal norms, including the technical imperfection of some legal norms, their ambiguity and others. Nastasiak, thoroughly analyzing the theoretical heritage of Western scientists, believes that the interpretation of legal norms is the activity of state bodies, various organizations, and individual citizens aimed to clarifying and explanation the content of obligation binding will of society expressed in legal norms. As a separate type of legal practice, interpretation presupposes the presence of a subject, the result of any activity, and a set of rational methods of activity designed to ensure true proper results. At the same time, the scientists rightly note that the interpretation of the law is also an integral part of the process of implementing legal norms, primarily their application by state bodies and officials. She writes about the stage of the proposal of interpretation by Kaplina, but her point of view is somewhat different from the one given above. Thus, according to the scientists, clarification is not always a mandatory stage in the process of interpretation a rule of law. The scientist notes that each stage of the interpretation process has its own features, specific characteristics, purpose, content, form, and methods of implementation. Clarification is the first element of interpretation and provides an understanding of the legal norm in the process of lawmaking, application of legal norms, systematization of normative acts. As the scientist rightly points out, the solution to the question of the stages of interpretation and their interrelationships depends on what type of interpretation is carried out, on the subject composition as well all the purpose of legal interpretation activity. So, for example, during unofficial interpretation, especially its everyday type, explanation of the rule of law for oneself is often carried out, but the purpose of simple familiarization, elimination of obligations, possible errors in the use of grant rights, etc. There is no communicative goal here. There is no information connection between subjects. At the same time, doctrinal and professional interpretation does not exclude, but on the contrary, implies the need to explain the content of the legal norm to the participants of specific legal relations, since it is carried out by qualified lawyers. During the official interpretation, the explanation takes the form of an explanation of the meaning of the state will, expressed in normative acts, which became possible as a result of clarification and is reflected in the motivation of the adopted decision. Thus, it is impossible to find out the meaning of a legal norm outside of the activity of its explanation. That is the disclose of its content, just as it is impossible to imagine the explanation of a legal norm without a preliminary process of cognition. Therefore, in Kaplina's completely correct opinion, clarifying is the meaning of a legal norm during interpretation and explanation. Also, closely interrelated are independent process. Clarification is an important but not necessary element of the interpretation process. However, it is an integral part of law enforcement interpretation. Such an approach to the understanding of interpretation, which combines clarification and explanation, allows us to talk about the interpretation of legal norms as a method of knowledge on the other hand, and about interpretation as a type of legal activity and the other. Yuri Vlasov defines interpretation of legal norms as an intellectual violational activity of an objective and subjective nature to clarify and explain the will of the legislator, materialized in the legal norm and results of this activity. At the same time, the scientist like Kaplina clarifies that the ratio of clarification and explanation should be established according to the purpose of interpreting legal norm. In the process of interpreting legal norm for the purpose of understanding its content, verification acts as an independent process of cognition. When the goal is to clarify the content of legal norm, clarification and explanation constitute a single process aimed to bringing the content of the norm to third parties. Kostenko difference between one or other two indications of intellectual violation process, which results from the previously established significance of the explanation and clarification. A rather unconventional approach to the improvement of damage in sorry. As we have already predicted, Vlasov confirms that in legal activity, the corruption of legal norms has a place not only of law enforcement, but also in lawmaking, law implementation, systematization, legal education, and propaganda of law. At the same time, as the clarification, the legal regulatory environment needs to take a closer look to its supporting duties and functions from other types of legal activity, such as legal specification, the establishment of norms until new minds or life and others. Kozubro recognized the fact that the investigation is not limited to explanation and clarification, but rather to make a number of important verifications in order to carry out the execution of the orders. So, in the end, lawmaking, of course, is not a function. It is one of the main directions of activity. Of lawmaking bodies, including courts. Endowing them with such a function would be effective in accordance with the principle of the division of power, which opponents of judicial lawmaking generally listen to. Therefore, mechanically transferring to the domestic legal system as well as to the continental legal family instead of the English judge-made law is truly incorrect. At the same time, Kozubra said that let us excuse ourselves from looking at the law enforcement body. First of all, the judicial practice and especially the practice of bodies of constitutional control, constitutional courts, as it stands close to the law-making process. The presence of elements of lawmaking in the legal activity is not an anomaly as it often described in the scientific literature, but an objective necessity is that may be within its borders. The defense cannot be excluded from the activity of the Constitutional Court and courts of foreign jurisdiction as laid down in the very nature of their activity. Kozubra signs, in order to convey the obvious facts of the passage of the ships uh, at a mile beyond the explanation and clarification of the will of the constitution maker and legislator, of external constitutional and legislative provisions that ought to be remote change. This is a story that is often teased about the fact that having become the constitution maker and legislator means being deprived of positions of extreme formalism and dogmatism, which are not incompatible with current manifestations about the right and place of any person. At the same time, the knowledgeable legal theorist clarifies that what has been said doesn't mean or at all that judicial deliberation, lawmaking, and judicial procurement and development of law don't exist between and are determined exclusively by judicial proceedings. In my opinion, judges can only go so far as to extract and develop the right lawmaking if on the basis of universally important arguments for and against, they come to the conclusion what without elements of lawmaking, the implementation of this or that other human right or it is otherwise apparent if the arguments for ensuring the rights of people appear to be significant, transforming in the higher values into arguments for extending the principle of division of power. Human rights are the basic creation that distinguish between judicial proceedings and lawmaking. Analyzing the stated approaches to the interpretation of law, we must state that we don't share the opinion of those scientists who either in this that interpretation is conditions of our legal reality is actually a lawmaking process or allow exceptions from the rule of the traditional understanding of interpretation and try to explain the logic individual decisions made by jurisdictional subject, which in fact are not only law enforcement acts or specific cases, but also acts that were subsequently applied by other subjects of law, which took as a basic the motivational and resolutive part of correspondent court decision. In this context, at the example of such an approach, it is considered necessary to turn to the works of Жанна Melnik-Tomenko, who in particular writes that in process of interpretation, a new norm is not always created, and as a rule, only the existing one is interpreted by the law enforcer. As a result of this mental and violational process, a specific legal prescription, so to speak, is prepared for its application and its ready form becomes the basis of specific law enforcement act. However, it should be recognized that in some cases in the process of law enforcement, such an effect of the interpretation of the norm is possible, as a result of which a new rule of law is created, which can be applied by other subjects of law. It is characteristic that the domestic scientist, in support of her thesis, cites an example of such practice. The Grand Chamber of the Supreme Court came to the conclusion that a public association with a relevant field of activity has the right to apply to the court in order to eliminate violations of the requirements of environmental legislation by a user of environmental sources and be filing such a lawsuit. A public association actually exercises the powers of state authorities, which are supposed to monitor compliance with environmental legislation, thus replacing state authorities in the matter of monitoring compliance with environmental legislation, which is the basis for the conclusion that the relevant disputes are of a public law nature and therefore should be resolved in the order of administrative procedure. Recognizing the unconditional correctness of the adopted decision, we consider it necessary to emphasize that in this case too, it is not worth talking about the fact that the process of interpreting these norms of the Civil Code of Ukraine and administrative legislation, a new rule of law was created. In our opinion, the code only clarifies the understanding of the category subject of public administration, stressing that it can be not only a body of state power, but also a private entity to which, in fact, certain functions are delegated by the state, for example, control function. In other words, the court having actually explained the specifics of the understanding of the essence of this legal category, explained that in this case, the public organization enjoys the same procedural rights as the state authority, and specified the specifics of consideration of legal disputes in this category of cases. But did the court create a new rule of law in this case? It seems that the negative answer to this question is otherwise. As a summary of the general overview of the above points of view of both domestic and foreign scientists, we know, we know that, as rightly noted on the pages of legal literature, from the numerous diversity of approaches to the definition of the concept of law interpretation, it can be concluded that, despite some deviations in the opinion of some researchers, the majority of representatives of both domestic and foreign scientific the schools agree that interpretation can be understood in two senses, as a process or as a result. At the same time, within the framework of this process, two other processes are carried out, clarification and explanation, which according to some scientists can exist as complementary components of single process and according to others are independent, not always connected among themselves by intellectual violational process, interpretation, clarification, and interpretation, explanation. Through the analysis, it was possible to gain respect for those that one of the same legal activity is designated by these and other predecessors by various terms, interpretation, concretization, exegesis, hermeneutics, interpretation value activity, right wing activity, and others. Without dwelling in detail on the complexity and importance of the of interpretation from the dedicated categories, it is significant that our common understanding is related to such categories as exegesis and hermeneutics are pardoners fragments. For example, sorry, I have some problems with the text. Sorry. Of course, it is impossible to talk about the semantic similarity of interpretation and law enforcement activity, even taking into account the fact that these phenomena have common characteristics. However, interpretation is a component of the law enforcement process. Moreover, as a legal scientist believes, and it's worth supporting him in this. Without interpretation, one cannot imagine law enforcement as such. Clarifying the content of the norm, its interpretation is a separate stage of the process of applying the norms of law, which takes the place of stage of establishing the legal basis in the case during the selection and analysis of legal norms. Because without such an intellectual and willful activity as interpretation, the law enforcement body cannot apply the legal order that is taking this into account. This was agreed in with Cherdantsev's proposed statement and recognizing law enforcement as a broader concept that includes interpretation, which is a component of the process of applying legal norms. Interpretation should not be equated with legal specification. The essence of legal concretization is the issuance of a legal provision that does not go beyond the content of the legal norm, but contains a new element of detailing the regulation of social relations, which is not expressed in this legal norm. During the interpretation, only parts of the content of the legal norm are clarified, revealed, substantive, but new elements of legal regulation are not established. Concluding the review of the issue raised in this subsection, having formed a certain theoretical and methodological foundation for the study of general theoretical aspects of interpretation, we will allow ourselves to make some final conclusions and author's clarification regarding the stated theoretical aspects. In our understanding, interpretation is not a separate stage of type of lawmaking, as a result of which a new rule of law is created. It worth emphasizing that among the arguments stated above, the basis of our idea of interpretation lies in the fact that the word interpretation, uh, in its common language, means nothing else than determine the meaning, clarifying, explanation the essence of something, give some explanation and other. In the same context, Ushakov extremely accurately emphasized that the interpretation is a cognitive process aimed at understanding and explaining the phenomena of nature of social existence. In the humanities, this term is used to denote a way of knowing various objects of human culture, interpretation of works of art, cultural significance of material objects created by man. Our understanding of various written texts. In other words, the very semantics of the word's interpretation does not involve other intellectual relational process except clarification and explanation, and attempts to expand the meaning of the specified words by clarifying that a new norm is created as a result of the specified mental process contradict their generally known meaning. In our opinion, interpretation is a mandatory stage in the process of implementing law. Interpretation at the stage of lawmaking is characteristic of the Anglo-Saxon legal system. We note that if, for example, a jurisdictional subject interprets the category public legal dispute, he only clarifies its content and the characteristics of the legal phenomenon or subject indicated by the term. That is interpreted based on the legal definition of a public law dispute explains to interested parties whether their conflict situation falls under the category and whether this jurisdictional subject has a competence and scope of authority necessary of its resolution. Allow us to note that the so-called judicial interpretation about which Kozuber writes in the context of this discussion can indeed in some cases go beyond the legal implementation process and acquire the features of lawmaking, but only in the case, as it seems to us, if it concerns legal interpretation activities of the Constitutional Court of Ukraine and the European Court of Human Rights, which is directly provided for by the current legislation of Ukraine, according to which, for example, courts apply the practice of the European Court as source of law during the consideration of cases. At the same time, we agree with the fact that the certain result of interpretation set forth or in one or another court decision, primarily of higher courts, may be the basis for revising judicial practice regarding consideration of a certain category of case. It is obvious that in such cases the rule of law itself has not changed, but only received, so to speak, a new, more correct understanding and rules of its application. We also recognize that the results of law enforcement or doctrinal interpretation can have an impact on law making. If, as a result of such interpretation process of this or that law or legal norms, a certain error or incompleteness of the legal regulation of certain social relations was revealed and subsequently the lawmaker made appropriate changes to the legislation. We consider the correct point of view according to which the staginess and complexity of the interpretation process depends on the goals of interpretation and accordingly its varieties. In particular, if we are talking about the so-called unofficial interpretation, then this process is covered only by the clarification of legal norms and does not foresee the legal consequence of such an interpretation. If we are talking about official interpretation, then it's obvious that in this case, the process of interpretation takes place in two interrelated stages, clarification and explanation. Interpretation should be considered a synonym of such words and phrases as interpretive activity, legal interpretation activity, and others. The acquired interpretation with concretization, exegesis, hermeneutics, and law enforcement activity seems to be erroneous, since the specified words refer to other phenomena and types of activity. Therefore, the interpretation of legal norms is the intellectual and the violational activity of the interpreter, which is carried out on the basis of principles and with the help of methods of interpretation aimed at clarifying and or explanation the content of the legal norm with the aimed at correct and uniform understanding. I'm sorry, I must take a stop. Sorry. Увага! Повітряна тривога!
Good morning, Mr. Pavlov.
I'm sorry, it is a air alert in Ukraine. I must cover. Just a moment, I think it's maybe a few minutes.
Okay, thank you. Sorry. And all dear participant, bagi para peserta, mohon maaf sebelumnya karena acara pada hari ini di reschedule mungkin untuk waktunya kurang lebih saya juga tidak tahu karena barusan dosen dari Ukraine Mr. Pavlo memberitahukan bahwa di negaranya alarm peringatannya tiba-tiba berbunyi karena ada serangan mendadak. Mohon maaf sebelumnya, mungkin kita bisa reschedule di tahun depan. Terima kasih telah menghadiri acara pada hari ini dan bisa mengisi absen terlebih dahulu untuk mendapatkan sertifikatnya. Terima kasih. Yeah, it's okay, Mr. Pavlo. I hope everything will be okay. Thank you so much for Mr. Pavlo for today. Thank you.